Hi guys, and welcome to another episode of Atty. Javier's Philippine Law Lectures for Students. Today we'll be having an overview, or as may be applicable, a review of the topic of contracts under the Civil Code of the Philippines. Consistent with being an overview, today's discussion will be more general in nature, and if you would like more details, you can just watch my full series on obligations and contracts. Just look for the playlist on this channel. Or better yet, study the law and the textbook commentaries. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. A like on this or any of my other videos would also be greatly appreciated. This episode is also brought to you by digest.ph, which is an online law library with over 70,000 case digests and full texts of Supreme Court decisions, all of which are downloadable in Word and PDF formats. Use my promo code Javier Digest to get 20% off Digest subscription plans. Go check it out, digest.ph. Now we can begin. We start with the definition to provide context for the topic. So, what is a contract? Article 1305 of the Civil Code defines a contract as a meeting of the minds between two persons whereby one binds himself with respect to the other to give something or to render some service. So how do we know a contract exists? We test its existence by the presence of the elements. Now, don't be confused. If the question is, what are the elements of the contract? The correct answer is the essential, natural, and accidental elements. The essential elements are those which are absolutely necessary for a contract to exist, and these are consent, object, and cause, or COC. The natural elements of a contract are those which are derived from the nature of the contract and are presumed by law. So they exist even if the parties do not write it down. This is because the law forms part of every contract, especially since it is not expected that the parties will write down every provision of law in the contract, as this will result in unnecessary long and thick contracts which no one will read. One example of a natural element is a warranty against eviction, which is presumed included in a contract of sale. Now, the accidental elements of a contract are those which exist only because the parties choose to write them down in the contract. So these may be special terms and conditions such as date, place of performance, etc. Now, let's discuss the essential elements, which are again consent, object, and cause. The definition states that the contract is a meeting of a minds, and this is the element of consent, which according to Article 1319 is manifested by the meeting of the offer and the acceptance upon the thing and the cause which are to constitute the contract. Consent requires three elements: concurrence of the offer and acceptance, that both parties must have legal capacity, and consent must be intelligent, free, spontaneous, and real. For consent to exist, there must be an offer, which is accepted. The offer must be certain, meaning it has to be definite, complete, and intentional. So it cannot be done partially or as a joke. Acceptance must be absolute, unconditional, and unqualified, because otherwise it will only constitute a counter offer, which will not create a contract. In case of a counter offer, the offeree now becomes the offeror, and the original offeror will have to accept the counter offer so that the contract can be perfected. And this cycle will continue with each new counter offer until one of them gives absolute acceptance. Thus, the first element of valid consent is the concurrence of the offer and the acceptance. Now, if the offer and acceptance do not meet, then the contract is not perfected and no contract is created at all. Now, the second element of consent is that both parties must have legal capacity or the power to perform acts which produce legal effect. Thus, minors and deaf mutes who do not know how to write, they cannot give consent. Insane or demented persons also generally cannot give consent, but if they are acting during a lucid interval, they can give consent and the contract will be valid. Drunkenness or being under a hypnotic spell, if shown to completely obscure the mental faculties of a party, these two may constitute temporary impairment so as to affect legal capacity. Now, if one of the parties is incapable of giving consent, then this results in a defective contract, specifically a voidable contract or one which is valid until annulled. However, if both parties are incapable of giving consent, this results in a different kind of defective contract, namely an unenforceable contract, meaning one which cannot be enforced by court action. The third element of consent is that consent must be intelligent, free, spontaneous, and real. In short, consent must not be vitiated, which means that it should not be spoiled or impaired. And how is consent vitiated or impaired? If consent was obtained through mistake, violence, intimidation, undue influence, or fraud. Okay? If any of these vices impair or vitiate consent, then this results in a defective contract, again a voidable contract, which is one that is valid until it is annulled. Let's go through them one by one. For mistake to affect consent, it has to refer to a mistake of fact, meaning either a mistake as to the identity, substance, condition, or quantity of the object, or it has to be a mistake as to the identity or qualification of one of the parties. So the object or one of the parties. Now, in general, a mistake of law, okay, earlier it was mistake of fact. Now, a mistake of law will not generally affect consent unless it is a mutual mistake on the legal effect of an agreement when the real purpose of the parties is frustrated. In other words, mistake of law can only vitiate consent when it pertains to a doubtful or difficult question of law. Otherwise, the general rule that ignorance of the law excuses no one will apply. Violence, intimidation, and undue influence also impair consent, because if they are present, then consent is not given freely. Violence requires physical force, which must be serious and irresistible. Intimidation must be of a reasonable and well-grounded fear of an imminent and grave evil upon the person of the party, his property, or the person or property of his spouse, descendants, or ascendants. The fear must be reasonable and well-grounded, so it cannot be merely an imagined fear. Okay? Undue influence is the taking of improper advantage of one's power over the will of another, such as when a supervisor uses his position to convince his subordinate against his will to enter into a contract. Now, for fraud to impair consent, it has to refer to causal fraud, or insidious words or machinations that induce a party to enter into a contract. It is causal, meaning it is the cause or reason why the party wants to enter into a contract. In other words, if not for that fraud, the injured party would never have agreed to the contract. So since this kind of fraud affects consent, the remedy is annulment. Consent, however, is not affected by incidental fraud. Okay, which is fraud in the performance of the obligation, because such kind of fraud only takes effect after the contract is perfected, It's fraud in the performance. In which case, the remedy is damages for breach of the contract. Because here, in incidental fraud, the contract is valid in the first place because consent was freely and intelligently given. So again, it is causal fraud that serves to vitiate consent and make the contract voidable. Now, whether it is legal incapacity or vitiation of consent, the injured party may choose to annul the contract because consent was not freely or intelligently given. The contract is defective because the element of consent is also defective. But if there was a meeting of the minds of both parties, meaning both validly gave consent, but the contract fails to express the true intention of the parties due to mistake, fraud, inequitable conduct, or accident, then the remedy is not annulment, but reformation, which may be brought under Rule 63 of the Rules of Court. So, for instance, if X agrees to buy 5 kilos of rice from Y, but by mistake, what was written in the contract was 5 pounds of rice only, then an action may be brought to reform the contract to correct the unit of measure from pounds to kilos, since it was kilos that was agreed upon in the first place. To emphasize, if mistake, fraud, inequitable conduct, or accident resulted in the failure of the contract to reflect the true agreement of the parties, then such as writing pounds instead of kilos as in the example, then the remedy is reformation. But if consent is absent or vitiated or impaired, then there is no meeting of the minds, or at the very least, the meeting of the minds was defective. So in that case, the remedy is annulment. Okay? Note, however, that reformation is not available for simple unconditional donations, wills, and void contracts, because there's nothing to reform in a void contract. Okay? The next essential element of a contract is the object, or the subject matter of the contract. And almost anything can be the object of a contract, even future things, as long as it is within the commerce of men and subject only to the limitation that the object must be determinate or at least determinable as to kind and quality. However, certain things cannot be the object of a contract, such as future inheritance, impossible things or services, and services which are contrary to law, morals, customs, public order, or public policy. The final element of a contract is the cause, which may be different for each contracting party. Specifically, in onerous contracts, the cause for each contracting party is the prestation or promise of a thing or service by the other. In remuneratory contracts, the cause is the service or benefit which is being remunerated, and in contracts of pure beneficence, the cause is the mere liberality of the benefactor. Note that motive is different from cause, such that motives do not affect the validity or existence of a contract, because motives are simply the personal psychological reasons why a party wants to enter into a contract, whereas the cause is the juridical reason for the existence of the contract. Thus, as stated by Tolentino, the cause for every seller is to get the money, but the motive may be different for different sellers, such as one would want the money to pay off a debt, the other might want the money to invest in something else, etc. No? The only time that the motive may affect the validity of a contract is when the motive predetermines the purpose of the contract. Okay? Such that the contract will be conditioned upon attainment of the motive. One common example is a lease of land by a Filipino citizen to a foreigner for 99 years. While the cause of the contract is apparently lease, the obvious motive is to grant full control over the land to the foreigner, bordering on ownership, thereby circumventing the prohibition against foreigners owning Philippine land, because 99 years is way more than a normal human lifespan. In essence, it is as if he is already the owner. Now, the parties do not even have to state what the cause is in the contract, because the cause is always presumed to exist. But of course, the parties may choose to write down the cause in the contract. However, if the cause that they write is false, then the contract is void. Okay? Since the essential element of cause is now absent. Unless, of course, they are able to show that there is some other cause to support the contract. So now we know what are the basic parts of the contract: the essential elements of consent, object, cause, the natural elements, and the accidental elements. But how does one make a contract? We first have to understand the stages in the life of the contract, namely generation or negotiation, which is the preparatory phase where the offers and counter offers are made. Then we have the perfection or creation, where the offer is now accepted and there is a meeting of the minds of the offer and acceptance on the object and cause. And third, we have consummation, performance, or fulfillment, which extinguishes the contract. So to answer the question of how a contract is made or created, as a general rule, contracts are perfected by mere consent. Meaning that from the moment the offer and acceptance meet on the object and cause, then the parties are now bound to comply with the contract and all its consequences. However, this only applies to consensual contracts, because real contracts such as loan, deposit, and others are only perfected upon delivery of the object. So again, in case of real contracts, aside from the meeting of the offer and acceptance, there is an additional requirement for perfection, that the object be delivered. So, as long as the essential elements of consent, object, and cause are present, then a contract can be perfected or created. Is there a certain form that is necessary to create a contract? No, because as a general rule, Article 1356 states that contracts shall be obligatory in whatever form they may have been entered into, provided all the essential elements or requisites for their validity are present. Thus, you do not even have to write a contract on a bond paper, to buy soft drinks from the sari-sari store. As long as the offer and acceptance meet to form consent over the object, which is soft drinks, and the cause of obtaining the price for the seller and obtaining the soft drinks for the buyer, then there's already a contract, even if you don't write it down in the bond paper. Note that a receipt, that's not a contract, okay? At most, it is only proof after the fact that a contract has been created and that the thing has been received, as well as the consideration or price. Again, the general rule that as long as there is consent, object, and cause, then a contract can be in any form. However, if the law requires a certain form for a contract to be valid or to be enforceable or for proof, then the contract has to be in that form. Okay, it's mandatory. One example of a required form for validity is that a donation of real property like land, it has to be in a public document. And if not, then the donation will be void, because again, that form is required for validity. If the form is not followed, then the contract is not valid. Better word is void. Remember, validity is different from enforceability, because validity refers to the existence of the contract, while enforceability refers to the capability of being enforced in court. So if the law requires a certain form for enforceability this time, such as in the case of statute of frauds, and the form is not followed, then validity is not necessarily affected. What is affected by the failure to comply with the requirement is only enforceability, meaning that the contract cannot be enforced or proven in court. One more instance when the law may require a certain form for contracts is for public or greater convenience. Now, according to the principle of relativity, a contract only takes effect between the parties, their assigns, and heirs. It will not affect third persons or the public in general because it is only a private document. However, if the contract is notarized by a notary public, it now becomes a public document. Okay, because it is recorded in the notarial register and a copy of the contract is sent to the clerk of the court of the jurisdiction of the notary. Now, the requirement of notarization or form for public document or for public convenience, that does not affect the validity or enforceability of the contract. So even if a contract is not notarized, that does not necessarily make it void. Okay, unless of course there is a particular law requiring that a document be a public document in order to be valid. Okay, as mentioned earlier. Now this the only effect rather of failure to notarize the contract is that the contract will remain to be a private instrument or private document. And what is the consequence of this? The document or contract will only be binding between the parties and will not affect third persons. Okay, it will not bind third persons. So what is the remedy of the parties? No, they can compel each other to observe the required form and have the contract notarized. Now, assuming that a contract has been created, it is subject to certain rules, including those rules which are inherent in the essential characteristics of contracts, namely autonomy or freedom to contract, mutuality, relativity, and obligatory force. The principle of autonomy or freedom to contract in Article 1306 provides that the parties may establish such stipulations, clauses, terms, and conditions as they may deem convenient. They can put whatever they want, as long as it is not contrary to law, morals, good customs, public order, or public policy. The principle of mutuality in Article 1308 requires that the contract must bind both contracting parties, meaning the validity or compliance of the contract cannot be left to the will of one of the parties. A party cannot say, I will give you 500 pesos if I want. Okay, he cannot say that. Why? Because there is no way to enforce that. And he can simply refuse to perform in order to avoid liability. The principle of relativity in Article 1311 states that contracts take effect only between the parties, their assigns, and heirs, except in case where the rights and obligations arising from the contract are not transmissible by their nature, by stipulation, or by law. So in general, third persons are not affected by contracts to which they are not a party, except in the following cases. First, contracts creating real rights, contracts which defraud creditors. Third, where the third person has induced a party to violate the contract. And in cases of stipulations por autrui, where as part of a contract, the parties have clearly and deliberately given a benefit to a third party who must accept it in order to demand compliance. And there may also be other instances, as may be provided by law, where contracts may affect third parties, such as in the case of public instruments notarized by a notary public. Now, the final principle is the principle of obligatory force in Articles 1159 and 1315, which dictates that once perfected, obligations arising from contracts have the force of law between the contracting parties and must be complied with in good faith. So the contract is the law between the parties and must be complied with in good faith. Now, in the course of the performance of the contract, issues may arise in relation to how should we perform this or what is the correct interpretation. And as a general rule, if the terms of the contract are clear and leave no doubt as to the intention of the parties, then you follow the literal meaning of the stipulations. Okay? But if the words appear contrary to the evident intention of the parties, then of course we follow the intention of the parties, because the contract is supposed to only be a manifestation of the intention of the parties. And how do we determine this intention? We look at the contemporaneous and subsequent acts of the parties. Now, if stipulation may have several meanings, you interpret it in a way that will make the contract effective. And you also have to interpret that stipulation in the context of the others. You cannot take the stipulation in isolation. You use context clues. Okay? And of course, if the doubt or obscurity is caused by one of the parties, then the contract will not be interpreted in his favor. Thus, contracts of adhesion, which are usually of a previously prepared format, which the other party cannot negotiate. He can only sign or adhere to. That's why it's a contract of adhesion. These contracts of adhesion are valid because the other party is free to take or to accept or reject it entirely. However, these contracts of adhesion will be interpreted strictly against the person who made them and liberally in favor of the party who merely signs. Now, as a catch-all rule, if there are doubts as to the incidental circumstances of a gratuitous contract, you interpret it in a way that will transmit the least amount of rights and interests because these are being given for free. So the interpretation should be one that does not abuse the giver. But if the contract is onerous, you interpret doubts in favor of the greatest reciprocity of interests. Why? Because since each party is getting something, you resolve doubts in a way that is fair to both. Now, if the doubt refers to the principal object of the contract, such that you cannot know what the parties intended to be the object, then the contract is void because you don't know what the contract's about. Now, another issue that may be encountered in the life of a contract involves what are known collectively as defective contracts, which include rescissible, voidable, unenforceable, and void contracts. Rescissible contracts are valid contracts because all essential elements of consent, object, and cause are present. But because of lesion or economic injury or damage is caused to one of the parties or to third persons, such as creditors, the law allows for rescission or cancellation of the contract. Lesion in law is the injury which is suffered because of a disadvantageous contract. Thus, a ward or an absentee is allowed to rescind a contract if they suffer lesion by more than 1/4 the value of the object of the contract which their guardian or representative may have entered into. So for example, the guardian sells a certain property of the ward at a 30% discount. So that's more than 1/4 the value of the property. He sold it ng palugi. Then, the contract is disadvantageous to the ward and the ward may ask for rescission from the court because of lesion or economic damage. Other rescissible contracts include those entered into in fraud of creditors because when these creditors have no other way to collect on their claims. Another is contracts involving things which are subject of an ongoing case under litigation but are transacted without the knowledge and approval of the litigants and of the court. Another would be payments that an insolvent debtor makes which are not yet due. Okay? The debts are not yet due and he has no money, yet he pays them. So the creditor who's defrauded can go after him for rescission of that contract. And of course, there are other contracts that may be specially declared by law to be subject of rescission. Is there a time limit to file the action for rescission? Yes. Rescission under Article 1381 has to be filed within 4 years from the date of the contract or from termination of the incapacity as may be applicable. And the action for rescission can only be filed by the injured party who suffered the economic damage, such as the ward, absentee, or creditor, or it may be filed by their representatives or heirs, or it may even be filed by the creditors of those people through subrogation. However, These people may only resort to rescission if there is no other remedy. Because unlike resolution in Article 1191, which is a principal remedy, rescission here under Article 1381 is only a subsidiary remedy. So you have to look for other remedies first. If rescission is found to be appropriate, it will only be allowed to the extent necessary to cover the damage caused. And if granted, then it creates the duty of mutual restitution, which requires the parties to return the things, object of the contract, with the fruits, price, and interest. Therefore, rescission is only available if the party asking for it can return what they are supposed to return, and if the things object of the contract are not legally in the possession of third parties in good faith, in which case there can be nothing to return. In the latter cases, since there can be no rescission, the remedy instead will be an action for damages. Now, voidable contracts, as mentioned earlier, are those which are valid until annulled, either because one of the parties is incapable of giving consent or because consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. Unlike rescissible contracts, which may be filed even by third persons in certain cases, the action to annul a voidable contract can only be filed by the injured party. Specifically, the injured party has two choices. Okay? They may either file an action to annul the contract within 4 years counted from the time he gains or regains capacity, or from the time the violence, intimidation, or undue influence ends, or from the discovery of the fraud or mistake. Or his other option is that the injured party or his representative may choose to expressly or impliedly ratify the contract, in which case the contract is now validated and cleansed from all defects from the time it was created. And of course, the action for annulment is extinguished, it's lost, because there's no more anything to annul because it's already valid. The annulment of the contract involving an obligation to give creates the duty of mutual restitution. As mentioned earlier, there has to be a return of the thing and the fruits, price, and interest as may be applicable, except in the following instances. First, if the contract was annulled because of incapacity of one of the parties, such incapacitated party only has to make restitution to the extent by which he was benefited. Second, if the thing is lost through the fault of the party who is supposed to return it, he only has to return the fruits and value of the thing at the time of the loss with interest. And third, mutual restitution does not apply if one of the parties does not restore what he is supposed to return. So, if the thing is lost through the fault or fraud of the injured party, then he will lose the right to file a case for annulment, because again, mutual restitution is required. However, in annulment of contracts involving obligations to do or services, there can be no mutual restitution since you cannot return a service. It has already been done. So what will be returned will be the value of such services. Now, unenforceable contracts are also valid contracts, but they cannot be enforced or proven in court unless they are ratified. And there are three kinds of unenforceable contracts. First, we have the unauthorized contracts, or those entered into in the name of another person by one who was not given authority or legal representation, or who has acted beyond his powers. Remember that under Article 1317, no one may contract in the name of another without being authorized by the latter, or unless he has by law a right to represent him. Therefore, if a person, the agent, enters into a contract on behalf of someone else, the principal, without being authorized, or even if authorized, has exceeded the scope of his authority, then that contract is unenforceable against the principal unless the principal ratifies it expressly or impliedly before it is revoked by the other contracting party. So the rules on the relationship between principal and agent are governed by the law on agency, which you can also watch on this channel. The next kind of unenforceable contracts are those that do not comply with the statute of frauds, which is a rule on evidence that requires that certain contracts have to be in writing in order to be proven and enforced in court. The writing may be in any form as long as it is written, because the purpose is to guard against fraud and mistake. Because of course, written evidence is stronger than mere memory, okay, which is faulty, unreliable, and fragile. While you can see the full lists of contracts required to be in writing under the statute of frauds in paragraph 2 of Article 1403, one example of a contract that must be in writing to be enforceable is an agreement for the sale of goods at a price not less than 500 pesos. Okay? This has to be in writing or else it cannot be enforced in court. However, since the statute of frauds is merely a rule on evidence, the contract may still be proven by other means. If the contract has been partially performed, such partial performance can prove that the contract exists because no one would make such performance without any reason. Thus, the statute of frauds only applies to executory contracts which have not yet been performed. If the contract is already executed or fully or partially, then the statute of frauds does not apply. Nevertheless, contracts which are unenforceable because of the statute of frauds may be ratified in two ways. First, by failing to object to the presentation of oral evidence to prove the contract. In trial, the defendant has the opportunity to defend himself from liability by saying that the contract cannot be enforced against him since it does not comply with the statute of frauds because it's not in writing. If the defendant fails to or forgets to raise that defense in court, then that is considered a waiver of the defense of the statute of frauds and the contract may now be enforced against him. So don't forget to use the defense of the statute of frauds if available, because it may be waived if you do not invoke it. Okay? The second way these contracts may be ratified is by the acceptance of benefits from the contract. Since you are accepting the benefits, you are recognizing that the contract exists as a source of those benefits. These two instances thus constitute implied admission of the existence of the contract. Of course, both parties may also expressly admit the existence of the contract, in which case the statute of frauds will no longer apply. The last unenforceable contract is one where both parties are incapable of giving consent. Remember that if only one party is incapable of giving consent, that is a voidable contract. But if both parties are incapable of giving consent, then the contract is unenforceable. Nevertheless, these contracts may be ratified expressly or impliedly by the parent or guardian or by the party himself if he gains or regains capacity. If ratification is only for one of the incapacitated parties, then the contract becomes voidable. So for the contract to be fully ratified, ratification must come from both parties or their representatives. Remember that because of the principle of relativity of contracts, only the parties to the contract can question its enforceability. Therefore, unlike rescissible contracts, unenforceable contracts cannot be assailed by third persons. Finally, we have the void contracts, which have no force and effect and are considered to never have existed. As a consequence of this, they cannot be ratified because there's nothing to ratify in the first place. And an action to annul a void contract can never prescribe because again, it never existed in the first place. So you can file an action for declaration of nullity of a void contract at any time. Moreover, since it never existed, it can never give rise to a valid contract. So the remedy is to make a new contract. And the following are void contracts: those whose cause, object, or purpose is contrary to law, morals, good customs, public order, or public policy. Second, those which are absolutely simulated or fictitious. Note that there's a difference between absolute and relative simulation of a contract. If absolute, the parties did not intend to be bound at all. So there really is no contract, and therefore the contract is void. But in relative simulation, the parties outwardly show that there is a contract, but they hide the real underlying contract. If the hidden contract is lawful, it is valid and enforceable between the parties. But as to third persons or strangers, the parties will be held to their ostensible contract because that's what they showed to the public. Okay? So remember, relative simulation is still valid depending on the circumstances, but absolutely simulated contracts are void. Third, other void contracts include those whose cause or object did not exist at the time of the transaction, or if the object is outside the commerce of men, or if it contemplates an impossible service, or if you cannot determine the intention of the parties as to the principal object. And the last kind of void contracts are those expressly prohibited or declared void by law. Now, in case one of the parties fails without legal reason to comply with the terms of the contract, then there is a breach of contract. And the remedies for breach will depend mostly on the kind of contract and its specific stipulations. But in general, the injured party may avail of specific performance, rescission under Article 1191 or resolution, and or damages as may be applicable. Otherwise, if both parties perform their obligations under the contract and there is no other issue, then the contract is fulfilled and will be extinguished. So that's it for a brief overview or review of contracts under the Civil Code of the Philippines. Remember that since this is just an overview, there are details that have been omitted and in order to focus on the essential points. So you can still watch the full series on obligations and contracts on this channel, or better yet, study the law and the textbook commentaries. So I hope you may have picked up a thing or two, and I hope to see you next time, guys. See you soon. Bye.